Hello and welcome to Legally Speaking with me, Tarun Nangia. There have been directions issued on how bail should be applied. The Supreme Court, namely Justice Vikram Nath and Justice Rajesh Bindal in a judgment, have issued these directions. And what these directions are, what regarding bail will change, or the guidelines, how will it have an impact? This is what we are going to discuss today. I have a very interesting panel. Justice Talwant Singh, now senior advocate, joins us. Good to see you, sir, and looking forward to some interesting insights from you as usual. I have with me Advocate Abhimanyu Bhandari, who practices at the Delhi High Court and Supreme Court. Good to see you. I have with me Sanjeev Sharma. He is senior partner with Sarafin Partners on the litigation side. Good to see you, Sanjeev. At the outset, may I request Justice Talwant Singh to make an opening comment. I think this is one of his favorite subjects, and he would be able to give us a good opening comment. Good to see you, sir, and your opening comment on this show.
Yeah, thank you, Tarun. Basically, I think this is a well-timed and much needed judgment. What is happening is that some of the lawyers and some of the litigants, they are now indulging in what we call is sharp practices. You know, by hook or crook, they want an order. And this is a classic example of that. I think there can't be any better example that you moved the Honorable Supreme Court against dismissal of your bail application in High Court, Orissa High Court to be specific. And then you again went back to the Sessions Court and then to the High Court without disclosing that your SLP is still pending before the Honorable Supreme Court. In Delhi High Court, of course, the directions which have been issued now, we were complying with these directions for the last many years. The registry puts up all the bail application numbers which were moved by the co-accused or by the same accused at any point of time. So we have the benefit of knowing that how many bail applications have been moved by this accused or by any other accused who is there in the same FIR, and whether those are pending or not pending. And as a matter of practice, the direction which is issued today is that these bail applications should be heard by the same bench, because there can be divergent of opinion on the same facts and circumstances. So one judge may say that I'll grant bail, other judge may say that I won't grant bail on the same set of facts and circumstances. To obviate this, even in otherwise in civil cases, in criminal cases where issues are same, parties are same, they are being taken up before the same bench. How this has happened in Orissa High Court, I can't imagine that two separate benches heard the bail application, which arose from the same FIR. So this is something which should not happen again. And I think the declaration which is now mandatory, that every lawyer has to declare or every litigant has to declare that there is no other bail application moved by him or her, or if the same is moved, where it is pending. So this is a very welcome step, and I think keeping in view the way the society is moving or the judicial fraternity is moving, I think we have to put these checks and balances in place.
Okay, point well taken. Thank you for that opening comment. I'll go to Advocate Abhimanyu Bhandari for his opening comment on the directions issued by Justice Vikram Nath and Justice Rajesh Bindal. Over to you, Abhimanyu.
Thank you, Tarun. Tarun, I think these directions are very important, and these directions will be welcomed by everybody who's the stakeholder in the judicial system, whether it is a lawyer, whether it is a litigant, or whether it is a judge. These directions must now be followed by every court around the country to the T, and we should not only in technically but in spirit understand that these directions are something which is binding on all of us, and these directions will ensure that justice is done. Now, I tell you, Tarun, bail is such an area of law where there is ample amount of discretion invested with the judge who's granting the bail. Bail is an issue which is also always very controversial. And I think in many cases, judges find themselves very caught up into that should bail be granted or not be granted. It's highly discretionary. There are, of course, parameters and guidelines. Now, given that it is such a discretionary area of law, these guidelines will bring in in an area where there is copious amounts of discretion, an element of accountability. Accountability of the lawyer who's appearing before the court, accountability of the judge who's giving the bail. So, for example, if a person has already moved 3 bails and does not disclose that the 4th bail that he moves, and the judge doesn't know that this is the 4th bail application he's moving, then the judge would not know what are the change in circumstances from the 3rd bail to the 4th bail, which entitles him to be reconsidered for a bail. So if 3 times judges have said there's no bail, there has to be a change of circumstances from the 3rd to the 4th. So according to me, the guidelines are very good. They are welcome. And I think it is high time that every court and every stakeholder adheres to these guidelines.
Okay. Good to hear that opening comment on the guidelines issued by the Supreme Court. I'll go to Sanjeev Sharma from Saraf and Partners for his opening comment. Over to you, Sanjeev.
Yeah. Thank you, Tarun. I absolutely agree with Justice Singh and Abhimanyu. In fact, I echo what their views also on these. And these are very useful guidelines and gives a very useful insight into, I think I would club it into 3 baskets. The directions are not only to the litigants, the directions are also to the registry, which has to list the matter. And the directions are also to all stakeholders so that there could be a proper administration of justice. Absolutely right, Abhimanyu, when you say that it's a discretionary issue. So discretion would definitely stay with the judge while granting the bail, but at least that discretion would be used judicially when all the aspects are before the court. So the directions are very important. These are welcome step. And what is important right now is that a uniformity has to be brought in, which has been brought in right now in listing, hearing the matters, and for the litigants also. The court has actually, what the court has noticed is a very unfortunate trend of litigants misleading the courts by providing wrong information or concealing the information. Actually, the word used in the judgment by the court is deceiving. So if a litigant tries to deceive, obviously it's an issue which is very serious. So for me, it's a very welcome step right now at the right time.
Quite well taken. I'll go to Justice Talwant Singh. So the directions issued by Justice Vikram Nath and Justice Rajesh Bindal are also to the registry, whom they have directed to annex a report generated from the system about decided and pending bail applications about the crime in questions. So do you see that these are sweeping reforms because of the registry will put this report to every application? What all needs to happen for this to be put into what you can say motion, or this to take effect? Could you just take it through this, because you spend a long time on the bench? You will be able to tell us what will happen from now on in courts.
Yeah, basically, in Delhi High Court, we have got a software that takes care of it. I think other high courts have to either develop or maybe they have to approach an IC to get the same software through which they can always, know that it is called, basically we call it grouping of cases. It's a sort of grouping of cases. It's grouping of the bail applications in a particular FIR. So the only parameter which you have to do the search is the FIR number. So the system should be able to give you, once you put this FIR number and the name of the applicant who has come to court this time, the system should be able to give you details of all the bail applications which have been moved till date by the same applicant or by other applicant, other co-accused, we can say. So this system has to be developed. I think till the computerization team takes a call and the system is put in place, manually it is not possible. Like a court, you say our Allahabad High Court, I think hundreds of applications are moved every day. So manually nobody can keep a track of that. It's some sort of, a caveat type of thing that one must know. Even it is a help to the prosecution side also, that they will also know that what is the status report which they filed in the earlier case or in the earlier bail application. So it will be more helpful to them also. And the system, once it is in place, it will be quite helpful, because in Delhi High Court, if you notice our cause list, on the cause list itself, all the related information is printed thereof. And it is helpful to the counsel of the applicant also, that even if he has not mentioned any bail application or he has missed out, because he will be mentioning only his the bail applications earlier moved by his client. But he will simultaneously come to know that there are other bail applications also which were moved by the other co-accused. So I think the call is to be taken by the IT department of the High Court, and it will really help every stakeholder of the court.
Point well taken. I'll go to Advocate Abhimanyu Bhandari. So, Mr. Bhandari, do you feel Justice Vikram Nath and Justice Bindal have, if you take the whole of India and all the high courts into question, these are big reforms. I mean, the judge will have an electronic report in his hand with details of all earlier bail applications and other forums, developments in other forums on the case. Could you, in a sense, reflect on what is to come because of these directions?
I think these are sweeping reforms, and these are reforms which are welcome, and these are reforms that should be put into place ASAP. As I said, there is huge amount of discretion when a judge is granting bail. Therefore, it is very important that the judge who's going to exercise his discretion and decide whether to grant bail or not grant bail has this valuable information with him. What is this information? This is information about other accused also in the same crime, and how many bail applications those accused have moved, and whether they've granted bail or not bail. And this is a very important factor to take into account, because as you know, Tarun, in the jurisprudence of bail, there is the law of parity. For example, let's say that the main accused got bail in the High Court or has not got bail in the High Court and it's pending in the Supreme Court. And that matter is still pending. The judge in the High Court would have that information to see whether Supreme Court has issued notice against the High Court order or not issued notice against the High Court order, and other relevant factors. Second, I think it'll also make lawyers make appropriate arguments before a bail court. Please do remember, Tarun, that in most of the high courts in our country, from my own experience, large number of bail applications are listed every day. And therefore, with this information, the lawyer should now be only focused on making the most relevant argument, knowing that this data is already with the judge who's going to decide the bail application, and therefore not really waste time in making arguments which would not cut ice, because one would burst that like a balloon, because that data is with the judge. So I think that's a very welcome reform that has come in. I think what is very interesting in this whole thing, and this whole judgment, is that there's one more thing which is a takeaway to the entire bar and to all the lawyers who appear for a bail, for applicants looking for bail. The court has specifically said that the counsel appearing for the parties have to conduct themselves truly like officers of the court. If there is one area of law where every counsel should really, move above from the needs of his client and the pressure that he has to perform in the court, is in the area of bail, because here really you're knocking at the complete discretion of a judge. And we are living in a country where, if a judge, and this is my personal experience, and, Honorable Justice Salwan Singh and Mr. Sanjeev Sharma may be able to throw some light on it. But my personal experience is, and, I should not hide this when I say this, is that whenever a judge in a lower court or in any court grants bail to an economic offender, there are multiple chats about it. There is too much of a discussion about it. Why did he grant? What did he look into? And therefore, it is very important that the judge who is going out and granting relief and liberty to an accused in big cases has this information, so that when he's exercising his discretion, he knows really what he's doing, and no one is really misleading that court into making some order. Lastly, I think that the court was very generous, and mercy, as we say, as Shakespeare says, is double blessed. Notwithstanding in this case the way the applicant behaved, the court did not cancel the bail and left it to the discretion of future judges in future cases to decide whether in such situations where a court is misled, should the bail be cancelled or not cancelled. In overall, I think this is a landmark judgment, and the reforms are much wanted. And I think this will bring in more accountability in the entire jurisprudence of bail.
A point well taken, that these are, in a sense, this was about time that these directions are issued, and they are most welcome. I'll go to Advocate Sanjeev Sharma, partner with Saraf and Partners, for his intervention on what the other two panelists have said and also his comments.
Yeah, absolutely. In fact, I just want to, upfront say this. I really want to salute the prudence of the bench, the judges who actually passed this judgment. It was very easy to carry it away and simply admonish the litigants despite the fact that they have clearly identified that the litigant is trying to mislead the court, despite that they were magnanimous enough, they were generous enough, just like Abhimanyu said, they focus on a larger issue. These are actually huge reforms which they have tried to bring in by passing of this particular judgment. So they were not focusing only on this particular matter. This was just a plan to basically pass these directions. And the directions, you can see the directions are not only for the litigants or the lawyers, that how they have to behave, what documents they have to file. It is also for the registry. So registry is required to basically ensure that the matter be placed in a particular FIR before a particular judge. So these are very clear directions, and then obviously to the various stakeholders, otherwise also how they have to basically respond to each and every issue which is relatable to judge. And discretion, no doubt. Again, I think Abhimanyu has very rightly put that discretion is something in bail matter which is very important. But how to use it judiciously is something they can only do once they have all the materials in front of them. So these are sweeping reforms, no doubt about it. And the court is no doubt focusing on the larger issue instead of just going into this. That's why instead of cancelling the bail, they just impose a fine of 10,000 and basically directed that these are the reforms which are required and the need of the hour.
Okay, point very well taken, and good that we are able to take up this issue today. We'll take one closing comment from Justice Talwant Singh on the directions issued by Justice Nath and Justice Bindal.
Yeah, basically we see, I'll add one more line. There was one more stakeholder who was either negligent or he intentionally did, was the investigating officer. In fact, the report which was received from the state law department says that the prosecutor was not the same. So he was not knowing that the other bail application moved. But the IO remains same. He was the same IO in district courts, the high court, and he must be the same person who was contacted by the state counsel from Supreme Court also. So he should have pointed out to the court that, look, this is what had happened in the earlier bail application. This guy had earlier, this accused had earlier moved another bail application. Okay, but as I think the entire panel agrees that very magnanimous and very, you can say, generous order that the accused or the person who was bailed out has not been touched and it has been left open. And a token fine of, I think, cost of 10,000 has been imposed. That too, I think, will go to the mediation center or something in Odisha. So basically, the overall effect of this judgment will be felt by each and every stakeholder. The law of bails will have some more clarity and stability. The judges will now exercise an informed discretion. Of course, discretion, I can't say it's total discretion, but of course, we follow certain principles also when judges decide these cases. But it will be an informed discretion. Judge will have every material before him, and then he will take a call whether to grant a bail or not. So, very welcome judgment, and it will be really remembered in the corridors of the Supreme Court and all the high courts, especially as a landmark judgment for the times to come.
Thank you. Thank you. Very quickly, closing comments from Advocate Abhimanyu Bhandari, followed by Advocate Sanjeev Sharma from Saraf and Partners.
I think the biggest onus on someone to be fair to the court is the lawyer of the applicant. And while this judgment says that all parties' lawyers have to be fair to the court, I think me being on the side of defense all the time, trying to get a bail, because I'm never on the side of the public prosecutor, I'm a primarily defense lawyer. I think that the onus is on us to tell the court if there is a background which is relevant to be told. The judgment also cites the Latin maxim that, suppression of truth is actually falsehood. And therefore, I think it reinforces and reminds, especially the defense lawyers, that, look, please don't take the court for a ride, because you're coming to the court and asking the judge to exercise a discretion. And therefore, it is extremely important that you bear open all the true facts before the court. So I think this is a great judgment. It reminds every lawyer what his duty to the court is. It also creates electronic reports, which judges would be valuable data. And I think it tells us that, look, if you want justice, be fair to the court.
Thank you. Thank you for the closing comment. Very quickly, Sanjeev Sharma from Sarafan
Yeah.
Partners.
So I think this judgment basically forces all the stakeholders to look into and introspect that what they are required to do, not to interfere in the administration of justice, which is actually the objective when you approach a court. So you want the court to adjudicate the issues. Actually, this judgment is sort of or acknowledges an extension of that judgment of Chengalvaraya passed by Supreme Court late 60s and 70s, which says that if you come to the court with an unclean hand, obviously your case would be dismissed at the outset. So this is what actually the court also acknowledges, that in a criminal jurisprudence, dispensation of justice required that the person should not come with a deceptive mind. It should not have an intent to deceive the court. So all the data, all the information, all the orders and every information has to be presented in a very clear and transparent manner, so that the court have a proper platform and proper information to use the discretion and use the discretion in a judicious manner.
Okay. Thank you. Thank you. Appreciate that all of you could make time and join us on these important directions issued by Justice Vikram Nath and Justice Rajesh Bindal in the field of bail jurisprudence. These will be indeed discussed for times to come. And we really appreciate you could make time. Thank you so very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.